afternoon. Welcome to join us for today's program. I'm Luan Wang, Director at the Washington State China Relations Council. And today we're going to talk about the Uyghur Forced Labor Prevention Act, the UFLPA, which was signed into law by President Biden in December 2021 in response to allegations of the use of forced labor in China's Xinjiang Uyghur Autonomous Region. A new guidance was issued by the U.S. Customs and Border Protection, CBP, in June. And these changes are of critical importance for anyone that in China handles trade and or has supply chains that import cotton, polysilicon, and many other goods that are commonplace in the U.S. market. For example, a survey last year found that 16% of cotton clothes being sold in the U.S. Contained fiber from Xinjiang. So we're very fortunate today to have three local experts to speak on this topic. Our speakers will provide an overview of the key points of the law later in the session. So I'm not going to review any more details here. What I'd like to point out is that this new guidance introduces significant uncertainty and challenges to the trade community because of the unprecedented scope of the imports that may become targeted for the new enforcement measures. And that's why we decided to host this webinar with these experts to unpack the complexities of the regulations and provide advice on best practices for business compliance. I'm sure you've seen the speakers' detailed bios in our event announcement. So I'll just briefly introduce them here so that we can dive right into the discussion. Our panelists today are Augustine Lowe and Ted Henderson. Augustine is a senior attorney at Dorsey & Whitney LLP, where he advises clients on international trade and the national security issues for cross-border transactions, including U.S. Customs international trade law, economic sanctions, export controls, and U.S. government review of foreign investments. Ted serves as Director of Customs the United States at Expeditors International, a global logistics company that many of you may know. Ted is a seasoned international trade compliance expert with over 30 years of experience in the field. And an interesting commonality between Ted and Augustine is that they both work at the CBP at early stages of their careers. Our moderator today is Nelson Zhou, partner at Dorsey & Whitney. Nelson is also the head of the firm's National Security Law Group and co-head of the Asia Group. He's a well-recognized expert on export controls, security and international trade, and investment matters, and U.S.-China relations. Among all the multiple hats that Nelson wears, I'd like to point out that he has been a longtime board member and supporter of the WCRC. For us to better understand the topic, our speakers also took extra time and effort to select several resources or readings out of a very, very long list of resources. And I'll post those links in the chat box momentarily for you to look at. Ted, Augustine, greatly appreciate that you did this for our audience. And as always, we'll start today's program with a moderate discussion for about half an hour, and then turn to the audience for questions. If you have questions for our speakers, please type them in the chat box, and we'll collect and try to address them all during the audience Q&A session. Nelson, the floor is yours.
Thank you very much, Mon, for that kind introduction. And I know both our panelists, Ted and Augustine, are looking forward to having a productive conversation with the audience today. Augustine, let me begin first with you to try to set some historical context for our discussion. It's long been known, in fact, for almost 90 years, that Section 307 of the Tariff Act of 1930 barred foreign imports made with convict labor, indentured labor, or forced labor, including forced child labor. So why did Congress move to pass this new law called the Uyghur Forced Labor Prevention Act? And what are the main differences between traditional Section 307 barriers and the new provisions?
Thank you, Nelson, for that question. And let me just start by thanking the WSCRC for the opportunity to speak with the audience today about this topic. So today our talk will focus a lot around an agency called U.S. Customs and Border Protection, CBP, or Customs, which has the primary role in enforcing this new act. Now, as Nelson said, for over 90 years, there had already been an import bar against goods made with prohibited types of labor, including forced labor. So why the change? Well, under the previous system, there generally had to be a basis for reasonable suspicion before customs could take action. So that oftentimes meant about a half-year timeline in which customs would first have to receive some kind of accusation that a particular product was alleged to have been made wholly or in part with forced labor, consider whether that evidence was sufficient before issuing what's called a withhold release order, or WRO, and formally instruct customs officers at the ports to begin detaining the same merchandise when they arrive at the ports for suspicion of forced labor and take further action. This was a sort of definitely a piecemeal process and directed at specific products, required a review of evidence beforehand, and Congress simply was not happy with this the slowness with which CBP was sort of the deliberation involved before CBP would actually take action with respect to products made wholly in part from Xinjiang, because of public allegations that in fact the suspicion was broader, that it potentially affected large, broad sections of products made wholly in part from that region. So essentially, Congress took the ball out of CBP's court and decided to impose a mandate that short circuits that process, and so that CBP must now automatically detain products if they're made sourced wholly or in part from the Xinjiang region or from certain entities, and are now subject to a presumptive bar that can only be overcome if an importer could both comply with certain due diligence guidance published by the government, as well as clear and convincing evidence that no part of the product is made with forced labor. So this law is significant in two respects, or several respects. One, CBP can now begin detaining the goods immediately, does not require any specific proof that a product was made wholly in part with forced labor. The burden has passed to the importer to show by clear and convincing evidence, which is a very high bar, that such goods are not made with forced labor at any point in the supply chain. And third, they must also comply with this extra due diligence requirement that's set out in the operational guidance, which was not previously the case.
Thanks, Augustine, for that quick introduction. So turning to you, Ted, the way Augustine described it, this seems a fairly stark shift in process for U.S. importers. How did the import community as a whole react to the new legislation, and how did the community try to advise CBP on implementation of the new law as it rolled out?
Thank you, Nelson. And let me also echo, as Augustine and you have said, thank you to the council for putting together this discussion, and for everybody on this conversation. Thanks for joining. And I think extra credit to, I see we have a couple of University of Washington students, and for getting on this call at 4 o'clock on a Wednesday. Tell your professors you get extra credit today for this one. I want to highlight there was indeed a high degree of concern and anxiety within the import community about the UFLPA, particularly given that existing actions that Augustine talked about that CBP was taking under Section 307 of the Tariff Act. They were already taking actions on certain goods from the Xinjiang region, and were targeting shipments and detaining certain goods from the region prior to the implementation of UFLPA under their existing authority. So the import community already had some experience with forced labor actions and detentions and what CBP would do in this arena. So there definitely was some concern when this new law was passed. I think some of the key points that were expressed from the import trade community were really mostly in a couple of key areas. One, an absolute desire for CBP to share information, whether that would be in CBP providing a list of known bad actors or giving full transparency to the reasons for the detention of a discrete shipment, or for CBP to share allegations and evidence related to current investigations where formal action hasn't been taken. But how about sharing that information so importers could get ahead of things when making sourcing decisions? Another common theme was around requests for guidelines on those standards of clear and convincing evidence. That was a relatively unknown area in the import trade world and the understanding that bar. Some folks asked if the CBP CTPAT program, which is the Supply Chain Business Security Program, that if trusted traders in that program could be maybe be considered separately when CBP was making detention decisions. Another really voiced concern was related to the challenges with having unrestricted access in China for comprehensive audits and supply chain mapping. It's very difficult to do as part of that overall difficulty in really completely understanding every aspect of the global supply chain, which is really required under UFLPA. And I think finally, given the very short runway that was stated in the statute, it was 180 days from the signature of President Biden to the implementation of UFLPA. There were really quite a few requests that CBP might exercise a phased-in approach to the implementation. CBP does use an informed compliance period on occasion for the implementation of certain new statutory and regulatory requirements. They've used that in the past. So the request was, could CBP do the same here to give importers a little time to vet and or change suppliers? And I think I do want to point out, particularly given the folks in the audience today, there were comments and concerns that were expressed by another group of stakeholders in UFLPA, and that was the NGOs, the CSOs, and certain academics. And those comments were really counter to what the import trade community was thinking about. So there were statements that really some of the foregoing requests that I mentioned from the import trade community were an attempt to water down the UFLPA and part of that larger effort to end the use of forced labor. Another common theme also from that sector was importers should be able to establish at all levels that their supply chains are clean. And then finally, there was quite a bit of commentary that the US government should be in a greater leadership position and do more to convince other countries to take action. So there definitely was a lot of discussion and concern from all angles with respect to in advance to the implementation of the UFLPA.
Augustine, coming back to you, to its credit, CBP did go through a pretty significant public outreach during the 180 days that Ted just mentioned, including appointing a forced labor enforcement task force that worked over several months to collate and curate the public input. What were the high points of the guidance that CBP issued in June, directed to the importer community, and how did that compare with the implementation strategy that the task force itself had announced earlier?
Nelson, thanks for that question. A point of clarification, which is that the Forced Labor Enforcement Task Force, or FLETF, was a creation of the US-Mexico-Canada Agreement, which is the replacement for NAFTA. And so this was an existing body that was interagency task force that already had sort of purview of this area of concern. And so UFLPA kind of built upon that by tasking it with a specific mission goal to create this strategy as a framework for how the law would be implemented. And then CBP's operational guidance is supposed to work under that umbrella. What actually happened was CBP issued this operational guidance first, followed a week later by the FLETF's formal strategy that's supposed to be the overarching structure. The guidance is—
Was there a reason that order got inverted that way?
Ted could feel free to chime in, but I did not hear any specific explanation as to why that was. But I suspect that the interagency task force required coordination across multiple actors at different agencies, where CBP is just a single agency and perhaps was able to move a little faster to issue its guidance.
I would absolutely concur with Augustine. There was no formal directive in this area, either in the statute or anything else that we saw. It really, to CBP's credit, they received all of that anxiety and concern and comment, not only through the public comment mechanisms, but directly. We gave direct comment to them. A lot of other folks did. And I think I know it was an effort on their part to try to get ahead and at least address the issues that they controlled. There were certainly much larger things in the strategy, like Augustine was talking about, that the FLETF had to deal with, but at least CBP did try to get ahead of things to say, here's what happens in the day-to-day scenarios that we control.
That's right. And ultimately, it is the CBP guidance that is most relevant for importers, because importers must interact directly with CBP to get these shipments through. And so, and the metric that they'll be measured against ultimately would be CBP's operational guidance. And that guidance does provide several key areas for importers. But first, I'd like just to set out the kind of timeline and framework with which this law will be enforced. So when the shipment arrives and presented to customs for inspection, CBP will have 5 days to decide whether or not to detain the shipment under this new law. If it decides to detain the shipment under suspicion it was made wholly or in part with goods from Xinjiang, or that it's made by one of the listed entities, then the CBP would formally detain the goods and issue a notice to the importer. The importer have up to 30 days to respond, and depending on the response, CBP will do one of several things. Either it will release the goods because the goods are in fact not at all made wholly or in part with anything from Xinjiang or from one listed entities, and such that the act does not apply, or it could release the goods because upon request of the importer, if they're so inclined. But they could also continue to detain the goods if, in fact, there's not sufficient evidence because the importer cannot show that it's entitled to what's called an exception to overcome the presumptive bar, or that it's failed to have a system in place that follows operational guidance. Or CBP could even proceed to seize the merchandise if it chooses to do so, with the intent to forfeit the goods. Thus, therefore, they would become permanently lost to the importer. It would become U.S. government property and to be disposed accordingly. So those are the potential outcomes. There are ways to challenge that, of course, whether under detention or in the seizure context. At that point, you would probably want to talk to a professional to engage to sort of figure out what's the best strategy for responding to these allegations to try and get out from under the UFLPA if at all possible and mitigate the loss. And as I discussed, one of the factors for consideration whether goods will be detained is if it's made with a listed entity. And here this is where the FLETF strategy is significant. The list of entities appears in the FLETF strategy, not in the CBP operational guidance. So you have to consult the strategy to figure out what entities are subject to this presumptive suspicion, on top of any goods that are sourced wholly or in part from the Xinjiang region.
Great. So Ted, returning to you, speaking on behalf of the trade compliance professionals who are staring at, in the face of this new law, the new guidance that comes out in June, you read it, I'm sure, cover to cover several times. What to you was most reassuring on the one hand, but also most disturbing about the way CBP proposed to implement the law?
I would say one of the most reassuring things were when we started hearing CBP start to make public statements that they would take a measured approach to the implementation and to shipment detention, and really not just start detaining anything and everything on 21 June when it was officially implemented. Again, the anxiety level based on previous actions that Customs was already taking under Legacy 307 and the withhold release orders that Augustine talked about there were already a number of shipments being detained for specific goods under that. So there really was a concern, knowing what is manufactured, mined, farmed, etc., in the Xinjiang region, that suddenly on day one, CBP would just stop everything. And so I think the first thing that helped calm folks down a little bit was the reassurance from CBP they would not do that. Outside of that, when we actually did see the guidance and like you said, read it cover to cover multiple times, was really getting clear information on the actual process that CBP would be following. We knew by the statute it would be a different process really all the way around from the existing legacy process for forced labor reviews. So it was nice to understand the specifics, to get to the timeframes that Augustine talked about, to get a feel for how this would actually be implemented on an individual shipment that's being offloaded in a port in the United States from an ocean vessel or aircraft, whatever it may be. So it really helped add some certainty to what was ahead of us. On the flip side, that guidance, like I said, was really very useful, valuable from an operational perspective. But both CBP made it very clear that they would not provide some of the things that I mentioned earlier that the trade was asking for. Yes, there is an entity list, which Augustine talks about, but if you look at it, it's a very short list. And by and large, the initial list is based on legacy 307 actions. It was not this suddenly, very large and comprehensive list that we could use, our import customers could use to make decisions on sourcing things along like that line. Also, Customs then came out and made it clear that they would not even explain why an individual shipment was being detained. They have a variety of reasons for holding that position, but there certainly was a hope that Customs might explicitly state on an individual shipment what troubled them, what was the entity that was involved in this, that's perhaps not on a published entity list. What was the connection to the Xinjiang region that somebody didn't see when they were initially sourcing and buying the goods? And really, I think the final thing is we still haven't gotten a really nice, complete understanding of what that clear and convincing evidentiary standard means. What does Customs need to make that leap to grant the exception?
Thanks, Ted. Augustine, as you were describing the June guidance that came out, it seemed that much of the CBP push on the importer community was in the nature of self-help to try to avoid getting caught up in a detention by having really good records so you could work within the timeframes that you sketched out earlier. And so that puts an emphasis on due diligence in a way that's much harsher in some ways than previous legacy proceedings. Can you go through the recommendations now that seem prudent for due diligence and record keeping that the importer community needs to think about?
Nelson, thanks for that question. Now, at the outset, I would like to second and repeat what Ted had mentioned, which is CBP has not said what is the actual level of proof that would satisfy the clear and convincing standard. What it has provided is a list of examples of documents that they may look to establish whether or not that standard has been met. However, so far as we can tell, there's not been any good examples of an importer that gives us sort of an understanding of what level of proof an importer had shown to satisfy that bar. There's been an existing law in place for a few years now with respect to North Korean made goods made by North Korean persons. The only examples we know that we're aware of under that act has been examples where CBP has denied the petition to release goods by finding that the goods did not satisfy that clear and convincing standard. So with that proviso in mind, the guidance does tell us that the CBP will look to 3 particular areas for compliance: due diligence, supply chain tracing, and supply chain management. With respect to due diligence, both FLEDF and CBP would like to see that an importer has already talked to its suppliers, mapped out the supply chain, and figure out where the weak links where forced labor could be involved. that there should be a supplier code of conduct that calls out this risk and tells people what they must do to comply, that there should be training of the relevant personnel within the company at the importer to identify these risks and to comply with the new law. And furthermore, there should be a system of monitoring, remediation, independent verification, and potentially even public reporting on the compliance efforts by the company. Now, these systems must already be in place for a company to comply with the UFLPA. It is not possible to create the systems ad hoc, basically, when goods become detained, because then, perforce, you will not have complied with the part of the law that requires a showing of the system to be having been in place to begin with. With respect to monitoring remediation, all these things are very good. We want people to be compliant with the law, certainly, but there are certain legal risks attendant to conducting internal reviews and audits of compliance issues. So probably an importer would want to discuss, consult some professional, like a legal professional, as to how to mitigate some potential legal risks attendant to internal investigations of forced labor issues and other problems. So that's just a caveat there. In terms of supply chain tracing, the guidance calls for a description of each stage of production, affidavits from each entity involved that will state, basically provide evidence that no forced labor is involved at that stage. Documentation, which includes the usual documentation you would gather from that the importer is expected to have to clear customs. But in addition to that, production records and other evidence relating to the downstream suppliers at each stage of production. So this is where the documentation requirement is much more extensive than in the past. Previously, there has not been this kind of due diligence requirement, this documentation requirement that requires an importer to follow basically the entire chain of supply chain back to the raw materials. That's essentially what this calls for. Okay, and there's even an annex that includes specific requirements with respect to cotton, polysilicone, and tomato products. These are products that already have been subject to regional WROs that customs had already imposed under 307, but are now kind of subsumed and incorporated into this UFLPA framework. And just based on conversations, discussions with various clients and other persons in the trade community, there's been significant pushback, especially from parties in China with respect to this aspect of the compliance. Companies are reluctant to share their confidential information, especially identities, relationships of downstream suppliers. So there could be a significant challenge in obtaining the kind of documentation that CBP is calling for here. And finally, supply chain management. The government expects you to have internal controls to ensure compliance and the ability to show that the documentation provided to the government is part of the official company books and records, particularly if it's for an accounting system that's an audited accounting system that would be reported for financial reporting purposes. So let's see. I'll turn this back to you, Nelson.
Thanks, Ted. The way the law, is framed, it has such a large focus on the Uyghur population and other ethnic, Muslim minorities in Xinjiang. You might come away with the impression that this just applies to goods that are produced directly in that province in China. But as the law is actually written, it talks about any items that come into the U.S. stream of commerce that are made in, quote, in whole or in part, unquote, from inputs that are sourced from Xinjiang or from other parts of China that may use workers who came from Xinjiang. So as a consequence, this really means the law applies to goods that could be made in factories coming into the US where the country of origin is declared to be Malaysia or South Africa or Colombia or Canada. But if any tiny little part, like the thread, that's used, to sew on a button, on a shirt, if that thread is from Xinjiang cotton, then the whole shirt is covered. So when you have that kind of exposure to this law, almost regardless of where you're buying your imports from, what does that teach U.S. importers to do at this point about due diligence and records?
So the short answer, quite frankly, is this is the huge challenge, Nelson, related to the UFLPA for importers. As you point out, the law specifically states that it applies to goods that are made in whole or in part from imports sourced from the Xinjiang Uyghur Autonomous Region. You know, most large importers, many importers in general, they have some sort of comprehensive due diligence activities that they've already been doing, maybe as part of their corporate social responsibility or their trade compliance programs, or maybe their supply chain security programs. Many of our import customers are actually out doing audits in the factories. So they're buying from a seller in Asia, and the factory is somewhere, you know, in a country maybe from the seller or not, and they're going to those factories to take a look at what's being done. But to your point, there are few, if any, who currently, pre-UFLPA, were going all the way back to the multiple tiers of their suppliers that would be connected to just a single article to identify the origin of the components and the entities involved in the production. And exactly what you speak about on that thread. If I'm sourcing a t-shirt from a seller in Vietnam, I may actually go look at the actual manufacturer for that t-shirt that my seller buys from. But under UFLPA, that doesn't do it. That's not due diligence. That's not what is necessary. You have to go all the way back to the origin of the cotton. Was it grown in Xinjiang? Was the cotton where was it ginned and spun? Where did that cotton thread go to be knit into cloth that ended up in my t-shirt, et cetera, ad nauseum? So that's the level you need to get to ensure that you can be reasonably confident that there's no forced labor in your product and you meet the UFLPA expectations. And I also want to call out another critical component of the Act that you did mention. It's certainly, you can't have components or inputs from the region, but the Act does state that your goods cannot be made with forced labor from Xinjiang, either within the actual region or individuals who were forcibly transferred elsewhere in China or somewhere outside of the country. So not only do you have to look at the inputs, you have to look at the workforce in every facility that produces those inputs. So bottom line, like you're saying, you just can't focus on goods originating from the region, and you can't even just focus on goods originating from China. CBP is already detaining shipments which originate from a number of countries because they believe there's a connection back to XUAR. You really, all of the things, unfortunately, that Augustine spoke to, that comprehensive due diligence on your goods, establishing that audit trail of supply chain traceability documents, that's what you have to do. And again, to emphasize what Augustine's talking about, you need to do that in advance of the shipment arriving in the United States. Doing it in advance demonstrates you are exercising reasonable care and you're doing your due diligence. But quite frankly, the detention period under UFLPA is 30 days. That's how long an importer has to respond to CBP and attempt to convince CBP that there's no forced labor connected to the detained shipment. There is no way in the world you're going to be able to accomplish that sort of the depth of work that needs to be done in 30 days. Man has already graciously posted the documents that we spoke of that we suggest you take a look at. There's more information in there. Take a look at those documents in the chat box, and that gives you an idea of the due diligence that you have to take on, the recommendations from the Department of Homeland Security and CBP. It's just a very different world than what the import community in the US has been operating under.
Augustine, you are primarily a litigator, and you also worked at one point as an enforcement official at CBP yourself. So take us through, if you will, a kind of a hypothetical case. Assuming you have a client whose goods have been detained, just as Ted said, the 30-day clock is running. What are the first kinds of records and materials that you will assemble to present to CBP? What do you present to the CBP officials as the first and second wave of persuasion to carry the presumption away?
Thank you, Nelson. At the outset, again, to second what Ted has said and what we previously described, hopefully the importer already has a system in place, right? That's one of the two prongs of the act, is you must already have a system in place that complies with the operational guidance. And then secondly, you have to be able to show by clear and convincing evidence that there is in fact no forced labor involved at any stage in the production. And this is where that kind of those affidavits, those extra documents, that documentary evidence, hopefully will be at your fingertips and ready to be provided to the government. Because as Ted said, it is not practical and it's almost impossible to gather that kind of information from downstream suppliers back to the raw material provider within 30 days otherwise. And also, mind you, that under the Act, CBP must publicly report on any what's called an exception granted from the Act when an importer actually provides sufficient evidence to overcome that presumptive bar. So CBP would have to publicly disclose the product involved and the information provided to meet that bar. So there's an inherent level of scrutiny, public scrutiny there, that perhaps makes the agency even less likely to grant the exception, so-called. So you really have to have really robust evidence to persuade the agency. A saving grace right now is it looks like CBP may in fact not have sufficient staffing to chase each and every instance. According to the strategy that was published, CBP expects to have to hire 300 additional personnel to be able to enforce this law next year. I'm going to guess they have not yet met that target. So as of today, they probably do not have sufficient people involved to really adjudicate cases to this level of detail at such a scale as they need.
Ted, because Expeditors does operate so globally and certainly in most ports of any size in the United States, what are you seeing on the ground? Or do you see different directors at different ports implementing and enforcing the law differently? Is there some pattern beginning to emerge that importers can think about or look out for?
So first off, we are absolutely seeing shipments, unfortunately, from our customers being detained under the UFLPA, and based on our own engagement with others, yes, there's quite a bit of activity under the UFLPA right now that CBP is undertaking. CBP did make quite a concentrated effort to educate from the headquarters down into the ports and explain the act and how it should be enforced within the ports and the things that were running there. So there was an effort in the lead-in, particularly. I think their timeline at CBP was late May through June, to try to drive consistency in how things are being managed in the port. I think, I want to call out something. I'm not sure if everyone saw this week, but there was a Wall Street Journal article published that was based on an interview with Robert Silvers, and Robert Silvers is the Undersecretary of Strategy, Policy and Plans at DHS. And in that article, he's quoted as saying that CBP has already targeted 1,452 entries. So an entry is a shipment valued at approximately $429 million under UFLPA. So if you look at that number, that's more than all of the activity customs took in the previous fiscal year in FY21 for under the Legacy 301. They're also continuing to target shipments under the Legacy 301 or 307 provisions, of the Tariff Act. So activity is already out there. I think we saw a somewhat slow start in the first couple of weeks as CBP was kind of getting their feet underneath them, but clearly they are absolutely detaining shipments, acting on shipments, requesting redelivery of shipments that were previously released. Things are happening along that line. Again, CBP sets the policy and the strategy and seeks to educate the ports, but CBP headquarters does allow a degree of latitude to the individual port directors to run things in their own ports. And some of that's just based on the infrastructure, some of it, there are a variety of reasons. So the actual execution of detention of shipments and what CBP is doing, yes, we do see that non-uniformity, some variance. Some of it, again, is a product of the actual port itself. Some of it is some folks are being more aggressive than others in the requirements they have. So one of the things that in this process, as an importer, you have the option to export your goods. You don't have to go through the process to try to gain an exception or allow the shipments to ultimately be seized by CBP. You can just turn the goods right around and export them. We're seeing different approaches by certain ports in the bonding requirements they're asking for, and some of the other minutia that settles around how we move freight around the globe and how we move shipments in and out of the U.S. So yes, there are exceptions. I think the other thing, the folks that are actually in customs who are reviewing this information, should someone ask for an exception, are within what's called the CBP Centers of Excellence. And again, you have an opportunity because there are 10 centers, they're virtual centers that encompass U.S. imports. You're going to see variation there on how they ultimately respond. But the key thing, as Augustine points out, if CBP is going to grant an exception, they are going to have to be very public about it. They're going to have to stand in front of Congress about it. So you can absolutely understand that ultimately things will bubble up to headquarters, to the task force, and to the executive directorate there before somebody takes action. So that will help standardize things as it goes. But really the overall targeting is managed at a national level. So the inconsistencies are somewhat minor at this point.
Thanks, Ted. I would like to ask audience members, if you have questions, this is the time to put them into the chat box so that Mon can direct them to our really excellent panelists who are speaking today, so that they will be able to have the questions that you want to ask and give you the answers you want to hear. I'm going to sort of move then to a slightly more contextual stage again. Augustine, at the very beginning of today's program, you talked about why Congress moved to adopt this legislation in the first place. Congress does read various reports, gets a lot of input from constituents and other advocacy groups. It happens that the Office of the UN High Commissioner on Human Rights did issue at the end of August a very, very critical report that had been gestating for 5 years in that office, based on investigations and eyewitness accounts of the situation in the Xinjiang region of China. That report was immediately denounced by the Chinese government, and some critics of the Chinese government either praised the report or thought it didn't even go far enough. So there's a lot of differences of view about that report. But how would you think that that will affect the sentiment in Congress about this kind of legislation, and whether there may be even more legislation down the line in this area?
Well, thank you, Nelson. Well, certainly the UN report and also reports from NGOs, civil society, could motivate Congress to take further action, impose other similar kinds of measures against products from other regions, for example. But with respect to Xinjiang, they've already imposed a regional bar, right? It's a presumptive bar that's applied to all products sourced wholly and part from that region, including, as Ted mentioned, from potentially elsewhere in China or in other countries where forced labor is suspected, with respect to particular persons' labor that's sourced from the Xinjiang region. So that's already a pretty broad approach, and so there would not be an immediate impact because of the UN report per se. But where there could be further influence from civil society would be with respect to targeting. So CBP does rely on allegations from NGOs and other groups to decide who to target under the existing 307 authority. Also, the FLEDA is charged with the task of updating the entities list, and so it could also consult that information to add further entities to be specifically subject to the presumptive bar under the UFLPA. Also, UFLPA has a sunset provision supposed to expire at the end of 8 years. Well, if these accusations keep piling up, then it's more likely that the law will be renewed beyond the 8 years.
input. Ted, I'm going to give you the last word here. You know, because of your role at Expeditors as head of U.S. Customs for Expeditors, and that means you really are in contact with so many parts of the importer community. Much of the discussion over the last couple of years, particularly because of various executive orders, has been focused on altering the habits of American importers and changing the nature and composition of their supply chains. Where do you see this law and its contribution to that reshaping of global supply chains? Are there going to be new sort of factory nations coming online? And if so, where do you see the trend going besides China?
So thank you for letting me close this out with that very fine question, Nelson. As you've alluded to, I mean, you know, when the trade remedy Section 301 actions were implemented by the previous administration here in the US, lots of folks were sure there'd be a massive exodus from China due to the additional 25% tariffs. But as we've seen, that didn't happen. So it's kind of hard to say at this point how this will actually impact companies' sourcing decisions related to China. You know, as we already discussed, the act doesn't just ban goods from the Xinjiang Uyghur Autonomous Region, it bans inputs from that region that might end up in goods produced elsewhere, and it bans goods produced by labor forcibly transferred from that region. The Xinjiang region certainly has a manufacturing sector, and perhaps goods from that sector could be identified for manufacturing in another country. But the region's really known for its agricultural and extractive outputs. It's been reported that the region supplies 20% of the world's cotton, 25% of the global production of tomato paste, 40% of the global production of polysilicon, and the list goes on from everything from hot peppers to walnuts to rayon to calcium carbide, beryllium, and so on. So I think we'll definitely continue to see efforts that started with the trade remedy tariffs to develop more manufacturing in places like Vietnam, India, elsewhere in Asia, the Indian subcontinent. But I'm not really sure how you can shift production to another country and avoid those key inputs that come from Xinjiang. So that really is the challenge. And, you know, I mentioned this previously, CBP is detaining shipments of goods with country of origin already outside of China. So I'm not sure you necessarily do any good to shift sourcing unless you really have a clear view as to all of your inputs. And the final thing I'd say on this is the US is taking a whole of government approach when it comes to addressing forced labor, and there are multiple government departments and agencies engaged in the area. Just today, the US Department of Labor published the 10th edition of its list of goods produced by child labor or forced labor, and there are 158 goods from 77 countries that are on that in that document that the US believes those are produced by forced labor. So we are talking about UFLPA and the focus on the Uyghur people, the Muslim population, the Xinjiang region. But I just want to highlight the U.S. is exercising its statutory authority across all countries. So, you know, bottom line, nobody wants to source, sell, purchase goods that are produced by forced labor. That's why the UFLPA had almost unanimous bipartisan support, unlike anything else recently in the U.S. Congress. And it was quickly signed by the president. But I just think right now it's a little early. We need to see how the rest of the world acts in this area. We know the EU is proposing legislation that to be adopted. More countries are implementing their strategy. We need to see how the US continues to build and develop its strategy, and we need to see where China goes on this matter. So I think it's just a little early to offer a definitive statement on the impact yet of this.
Great. Thank you very much for that final word. Thank you to Ted and Augustine. Man, over to you then. The moderator is leaving the stage here.
All right. So there are some questions in the chat box, and then the first two questions are actually related to sort of like, you know, the decision power or execution of the act. Augustine touched upon actually some aspects of these two questions, but I still wanted to ask to see if you have, like, you know, Ted, Augustine, even Nelson, if you have anything to add. So the first question is about, so who has a standing to challenge CBP's decisions, including exceptions? And then the second question, so Augustine talked about the 8 years of the act. 8 years, time frame of the act. But can you envision a day when so the act might just be returned to Congress as unworkable? So these are the two questions related to those perspectives. So I know. So Augustine, Ted, feel free to provide your comments.
Thank you, Man, for pointing out those questions. So the first question I'll address was with respect to standing. Nelson, of course, may also have some input from his earlier life as part of the DOJ. So in general, to have standing, you must have an injury that's traceable to government action in order to be able to go to court. And so in the first instance will be the importer and other commercial parties that have a direct connection to that import. And so to challenge CBP's decision as sort of to follow the pattern under the act, first you would you would respond to CBP's notice of detention within the 30 days framework, providing the evidence that's required under the act. If the goods are detained, you could follow CBP's existing procedure for submitting what's called a petition. File a customs protest, excuse me, and if the protest is denied, then the customs law provides for judicial review. You can go to the Court of International Trade in New York and seek judicial review of that denial of the protest. If they instead proceed to seize the merchandise for potential forfeiture, that may open up the opportunity to go to federal district court to challenge the seizure under sort of the other background body of law, which you can always challenge a government seizure of property and cite the reasons for doing so. But there, to go to court, you must have a standing. You must show that you, as a party, have some connection to the injury that's traceable and that can be addressed by the court. So Congress, for the most part, would not have direct standing there. They may have they may have a problem if they were to try to file a lawsuit to enforce the act on their own account. I think Nelson, you may want to, you're from your earlier life, you have some insight into that when a certain senator decides to challenge governmental action.
No, I think you summarized it pretty well. Ted, do you have any other input on that?
The only thing I would say is absolutely trying to follow a formal process would be challenging, but there's no question that congressional members, there are some that are very keen to call government leaders to stand in front of them and explain their actions. So this is certainly something that all of us as former government employees are very cognizant of from our agency experience, that you do have to periodically stand in front of Congress. So I think folks would exercise that option. And to the person who made that comment, absolutely, there are certain senators that this is near and dear to their heart, notably Marco Rubio from Florida. He's the person who's been driving a lot of this, and his cohort there in Florida, Mr. Scott, is also they've already put forward some more proposed legislation in this area about a week or two ago. So I think that would be the tool that Congress would use is basically a public accounting in front of Congress.
That's right, Ted. That is correct. So, in addition to the judicial path, Congress does have legislative oversight power over federal agencies, and so if they don't like what CBP is doing, they do wield the legislative pen. They could enact a new law that will command CBP to do something different, just as they have done with the UFLPA.
And I'll just pile on real quickly that second question. Do we expect that this act might come to close? I go back to my earlier comment that this is one thing that if there is one thing that US Congress has been able to unite around, it's forced labor. And the fact that nobody likes it, I just don't see us in the United States going backwards and saying, you know what, we just can't, CBP can't implement this act. I just don't see it. I just see that this remains standing. I don't, again, that's purely my own personal opinion, but that's where I think on this one.
Yes, assuming that there's not a fundamental change in policy with respect to these topics in China and the Xinjiang region, we could probably expect this issue to continue to percolate.
I mean, honestly, we just don't see a lot of acts repealed and in general, and I just can't see this one.
So thank you both. And then the next question. So it's fair to say that the overriding U.S. goal with all this is to reduce trade with China. And if so, does this mean the end of most companies, basically like small and medium-sized companies, but not those biggest and best funded companies? So, or at least those companies that buy products that might have been made with forced labor. So what's your take on that?
I'll jump in here. Nelson spoke to what were the apparent goals of the previous administration to control trade with China, and it's very clear that the current administration, in their own trade policy and some other areas, if you listen to the U.S. trade rep, how she speaks, there still is an effort to manage our relationship with China, for lack of a better term, here in the U.S. There's no question that this will be challenging for small and medium-sized enterprises. They just don't, we know this. We work with folks that are multi-billion-dollar global enterprises. We work with folks who operate out of their garage. And so we do see that there will be challenges for the small and medium-sized enterprises because they frankly would not have the resources to do due diligence and wouldn't even have the resources to pay a credible law firm like my colleagues on this panel or some of you in the audience or a consulting company or whoever to exercise due diligence. There are some companies that are in the data space and the tech space that are trying to come up with some interesting tools for mapping of entities and using non-public data. So one of the common things that gets called out is the Xinjiang Production Construction Corps as an entity within the region. If you look at that, that is basically a paramilitary unit that has oversight in the region and has hundreds of sub-entities around it. So there are folks that are trying to take data and mapping connections and using data charting to try to, at least provide an affordable mechanism for folks to look at connections within their supply chain. But again, there's no question it will be challenging. Depending on a final note, I'd say is how aggressive the U.S. Approaches this, U.S. government agencies. Augustine or others?
Yes, I would definitely second what Ted said. It is quite challenging in terms of having the resources available to do this. The larger companies, as Ted mentioned, already probably have social compliance policies and systems in place for the supply chains. But even then, they probably never had to do this previously to trace it all the way back to the raw materials. Even they probably face challenges trying to figure out what is actually happening on the ground in those regions, particularly in Xinjiang, in particular because of the fairly complex relationships that exist in connection with the XPCC in the Xinjiang region. Which is not only is a subject to this import bar, but is also that entity itself is also subject to separate U.S. sanctions. And so, so any company that wants to do business that has connections in that region will have to be on heightened alert.
Mon, can I offer one sort of closing comment, as the moderator here? I think it's, because of the general focus of the Washington State-China Relations Council over nearly a half century has been to help build relationships between the United States and China. I think it's important for our audience today to understand that most policymakers in Washington, while they're very anxious about this forced labor issue and many other issues that strain the relationship between the United States and China, there is, I think, overall a desire for something like a managed relationship. I think that was Ted's term earlier in his comment. I think back to Secretary Anthony Blinken's March 2021 speech setting forth the administration's China policy. And one part of that speech, I think, really expresses pretty well where the administration is trying to juggle all of these different competing interests all at the same time. What he said is that the relationship between the two countries will be, quote, competitive when it should be, collaborative when it can be, and adversarial when it must be. And I think that captures the complexity and depth of the difficulties right now in the trade relations, and why we're going through sort of microscopic exercises like the Uyghur Forced Labor Prevention Act. It's sort of one expression of one part of the concerns, but in the same day, the administration may be working on other issues to enhance trade cooperation or to lower tariffs or to do other things. And so we shouldn't become overly pessimistic just because of this one law. It does present much complexity and certainly makes work for people like Ted and Augustine and me, but at the same time, there are ways to deal with these laws, and deal with them we must.
Thank you, Nelson. That's really very well said. And also, there's also WCRC here who can provide help as we can. So if you have anything, China-related issues, we're happy to provide help, especially given this broad network of members and supporters now, Nelson, Augustine, and Ted. So we have a network of members and partners to provide help. So we have one more question in the chat box, and so I'll just raise that question and then we can close then. So the question is there any list of science-based evidence, such as DNA-based evidence, that is accepted by CBP to substantiate that a good has no connection to Xinjiang?
So there are a couple of companies and CBP themselves through their own lab and working with a couple of universities are working on that very idea of DNA tracing. You can do it with cotton to a certain degree. There are some other things that might be done along that line. So absolutely, there are a couple of companies that are in the private sector that are working on this, because obviously this would be a great revenue opportunity. And the government is also looking at similar areas as well. But again, that's only worthwhile with certain things like cotton.
That's right. It would not, for example, work with polysilicon and other things that are not organic. But I'm sure, as Ted said, over time, people will think of strategies to try and sort of figure out ways to try to provide circumstantial evidence as to where the things come from. It may still be challenging in processes where things tend to be commingled. For example, if you're for many processes, you in fact don't source from a single source, but source from different locations. You sort of combine it in a vat that's commingled, at which point it becomes more difficult to figure out where things came from initially.
Thank you, Ted and Austin. And I just lied. This is not the last. This was not the last question. I myself have a question. So this might be a small part of the import industry in the U.S., but does the law say anything about e-commerce products that ship directly to consumers?
The law. Sorry. So the law doesn't specify e-commerce as a particular focus. I mean, as a practical matter, e-commerce, if you're talking about sort of direct buyer to buy, what was it, direct B2, was it B2B,
C2C.
Thank you, C2C. Thank you.
Or B2C too.
B2C, right? So
Yeah.
basically, tends to arrive as small parcels and not part of formal entries or part of large shipments. Correct. And I guess customs in the past has not been able to necessarily inspect into the same level, with the same methods as large cargo containers, and perhaps things have slipped through. But that's not because the law isn't necessarily addressing them any differently, but because it's just isn't. It's just not the law is written is just not oriented towards that kind of that stream of traffic, right, Ted? Yeah.
I'll just build on that real quickly. As Augustine's pointing out, there are specific mechanisms, regulatory and statutory mechanisms in the U.S. that allow low-value e-commerce type shipments to move in sort of a different customs path than heavyweight shipments would. CBP can do extensive targeting on the heavyweight shipments based on their advanced targeting system and the data they utilize there. They don't have the same opportunity in e-commerce yet. Now they're working on that, and I have the pleasure of being on a task force for about the last 4 years on that subject with CBP. But so there are already things in place to address that. But back to the core question, the law itself makes no exception for low value goods. All goods are subject to the law. And the other point I would make is if you hear conversation about de minimis exceptions and low value exceptions, there is absolutely nothing in the law that allows for a de minimis consideration of your input. There was quite a bit of conversation early on when it came around polysilica a few years back, detentions, but customs has said that, and DHS, everyone has interpreted the current law to say it doesn't matter, back to Nelson's point, if it's a piece of thread that's holding a button on, that makes your goods potentially subject to enforcement under the Act. So there's no de minimis allowance in even the input consideration.
That's right. I think the confusion was because CBP previously had an FAQ guidance published about 2 years ago that was retracted.
Right.
Quietly on that point. But there is, yes, and in fact had the pleasure of speaking to one of the CBP's attorneys and confirmed that yes, the law itself does not provide for de minimis exception, and so they no longer interpret the law to say that.
Great, thank you. So it's 10 after 5, and I think we should conclude the session. And thank you again for Ted, Augustine, and Nelson for sharing insights. I've learned a lot. I'm sure our audience will be the same. And also thank you all of our audience to join us today. So just wish you a good evening, and I'll see you next time at our programs.
Thank you all. Take care.
Thank you. Take care. Bye-bye.
Thank
Bye.
you. Bye-bye.